Real people, real cases. This is Verdict Watch. Real
Circumstances have changed, hasn't it, Mr.
Yep.
Keene? She failed to report, and it's been almost a month of failing to report. So I will need a motion to be heard if she's accepted. I can't just go, okay, jail, let her out. They're not going to just let her out unless there's an order now. So I need to have a hearing. I need to be heard. Have you be heard? I need to do an order. The jail will not release her based on the fact, oops, she's been granted into this dual diagnosis treatment. They're not just going to release her.
Yeah.
Thank you. We will go on the record in the matter 24 CF 72, State of Wisconsin versus Stacy Shannon. The state appears through District Attorney Special Prosecutor Aaron Marco from video conferencing. We have Glenn Keene, Defense Counsel, on video conferencing. We have Ms. Stacy Shannon in person. We're set here today in this matter for a review hearing. The court sentenced Ms. Shannon on September 23rd, 2025. This was a different type of sentence. The court did order 4 months of jail or inpatient treatment. The court did provide 50 days, stayed the jail sentence for a period of 50 days to allow Ms. Shannon to locate an inpatient treatment facility or report to jail. Under Wisconsin statute 973.15, paren 8, paren A 2, 3, not 2. So it's 973.15, paren 8, paren A 3. Wisconsin statutes gives the court 60 days. It actually states for not more than 60 days, except that the court may not stay execution, blah, 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 that the court is allowed to stay a jail sentence for no longer than 60 days. So the court did stay it for a period of 50 days to allow Ms. Shannon to either report to jail or to find an inpatient treatment facility. Again, we had the hearing on September 23rd. 60-day mark would be November 22nd, 2025. It is December 17, 2025, far beyond the 60 days. She has not reported to jail, nor has the court received an inpatient treatment confirmation, or is she in inpatient treatment. Mr. Marco, the court also did receive today a very late filing. I'm not sure if you had a chance to read the motion to modify sentence. However, again, that is late. Plus, the court can't decide a motion to modify sentence based upon a quick filing such as this. That is a big thing for a court to do. Mr. Marco, what is the state's position?
Okay, thank you. First of all, I agree that this is a late filing. Attorney Keene provided a copy of that to me today. I have not received it through the e-filing system yet. That actually takes a little bit of time for my office to be able to process. Once it gets sent to CCAP, it gets posted, my office has to pull it. We have policies and procedures to do that daily, which has not been done yet. Mr. Keene was kind enough, however, to send me a copy of that. So being that it appears as though we're not ready to be prepared for that, I will state that I think that the result is that if we don't address that today, that Ms. Shannon needs to be in custody. I think that she also probably opened herself up for a potential failure to report to jail. And with the sentence being over 10 days, that's an additional felony. Now, I have not received a referral for that. I'm just letting the parties know that that was her duty and she didn't comply with it. I will inform the court that in speaking with Mr. Keene, it would have been my intent, or may still be my intent, when we do hear the hearing, to defer mostly to the judgment of the court. I'm not aware of the court's practices in this particular matter or Miss Shannon. I think that she is probably in a difficult situation and wasn't able to find her treatment as she was supposed to. It's a very difficult thing to accomplish. However, she seemed confident to be able to do it at the time of sentencing. The letter from the probation officer shows that she is definitely in a difficult situation, that she needs a dual diagnosis evaluation, that it's going to take 4 to 6 weeks for the first part of it to happen, and it's going to take another what was it, 14 weeks for the bed date. So this is nothing that's going to happen in a short period of time, even if she does try and rely on probation and parole. I still don't see anything that alleviated her need to report to the jail on the date in question. And that's probably, at least the day before, is when this should have been filed. My other main concern is the fact that it's reported that she failed a UA while she was waiting to try and get in the state portion of that 50 days for cocaine and THC. So while it is my intent to defer largely to the court and provided the accurate information that's necessary, the reality is the court already knows that. And if we're not prepared to go to the hearing today on Mr. Keene's motion, then I see no other option than she be going directly into custody today to start to serve that sentence. Whether or not I'll get a referral from Burnett County for failure to report has yet to be seen. I haven't seen one yet.
Mr. Keene?
Yes, Your Honor. I have gone over that part with Ms. Shannon as well. The only thing I would note that I would ask the court to consider, if the court agrees that Ms. Shannon would need to report today, and the late notice was so that I could discuss with Ms. Shannon the request for the court to modify it was because the recommendation of the Department of Community Corrections is recommending a treatment that would take longer than what her remaining court time would be. The only thing I would note is that Agent Locker informed and Ms. Shannon both informed me that he did have the
I would watch what you say and make sure that it's accurate. We do have Agent Lockers present here, right here in the courtroom.
Oh, okay. Right. That's great. Because actually, I was hoping he was here. I thought he would be up at a microphone so he could answer any questions of the court. The only thing I would ask, and then Agent Locker can, testify to the veracity of it, is that it's my understanding that she has a AODA, the assessment part, scheduled for Friday at 9 a.m. So I would just ask that if the court, feels the need to put Miss Shannon in custody at the time, I think it would be useful to find out from Agent Locker if the assessment could still be done if Miss Shannon were in custody. Because I know some don't go into the jail, some do. Agent Locker would probably have a better understanding of that than I.
Agent Locker, is she able to do the evaluation while in custody?
Yes.
Yes.
Okay. Then,
all right. Anything else?
Yes, Your Honor. I was just going to ask that the hearing be put on the calendar. I recognize the court wasn't going to be, or the DA's office wouldn't be able to hear it today.
We can't hear you. You're mumbling.
Oh, sorry. What I said is that I don't believe I was going to ask that the motion I filed be put on for a hearing at the court's earliest convenience, because I recognize that the court and the DA would not be able to hear it today.
All right. Well, the court is stuck. The law gives me no more days than 60. It says not more than 60. May the court stay or provide a report date to an individual who is going to serve a jail sentence. It's far beyond that report date. Again, that was November 22nd, 2025. A lot of this could have been handled a lot earlier with a letter to the court prior to that, with notification about inability to find a treatment facility. But we are far beyond that date. What happens and whether or not Mr. Marco files anything else, any other felonies in this matter, or whether or not Mr. Keene is able to speak with Mr. Marco about that, if he gets a referral, that's not any of the court's concern. Right now, I have to follow the law, and the law says that it has been over 60 days.
Judge?
I have no more than 60 days. I'll hear you, but you are going to jail.
Well, how long will I be in jail if my dual diagnosis treatment isn't going to be available for another, two months or so?
You'll be in jail until you can be released for your treatment.
Well,
Please take her into custody.
no.
That is the order of the court. We're going to set a hearing date right now. She has a 4-month sentence, and
Oh,
she is
God.
provided with good time. And the court will hear earlier if she's able to get a bed date earlier on a motion. But as of right now,
My God.
the hands are tied with the court and
What
with
is
all
this?
parties. Let's get a court date. I can do my next available court date would be January 13th. I have any time after 9:45.
Oh, my God.
I don't have anything that day, so
9:45?
9/13 or January 13.
Mr. Keene, does 9:45 work for you?
Yes, Your Honor.
January 13th, 9:45, we will have a hearing on the motion filed today to modify the sentence. The court, she should be allowed to have her evaluation while in custody for her dual diagnoses. We'll see, and we'll go from there. If at a later time we get confirmation that she is accepted, the court will entertain a motion then to permit her to be released from custody to be directly entered into the dual diagnoses. All right?
Your Honor. Your Honor, I would note that your original sentencing, it didn't require an additional hearing. The sentence was that it would be 4 months, and that was without good time or Huber. But that if it would be either location, the court did approve that if a bed or something was found, that she'd be able to be released to that.
Circumstances have changed, hasn't it, Mr.
Yeah.
Keene? She failed to report, and it's been almost a month of failing to report. So I will need a motion to be heard if she's accepted. I can't just go, okay, jail, let her out. They're not going to just let her out unless there's an order now. So I need to have a hearing. I need to be heard. Have you be heard? I need to do an order. The jail will not release her based on the fact, oops, she's been granted into this dual diagnosis treatment. They're not just going to release her.
Understood, Your Honor. My point was that if probation, the DCC found the bed, if they filed a letter with the court saying that they had the bed and the date, that could probably be done without the hearing. But
maybe you can file your information and I'll decide at that time if a hearing is necessary. Right now, it's in I know what I said in September 23rd, jail or inpatient treatment, 50 days for her to find inpatient treatment or report to jail. Right now, it's a jail sentence, straight 4 months jail sentence. That's it. So if she gets in, great. But right now, the court sees it as it's the other option of jail only.
yes, sir.
Lots of things could have been done a lot prior to December 17th, when her report date was November 22nd. Oh, actually, I think that was 60 days. I think I put in 60 days from that. Yeah, I did. So let's see, 50 days from September 23rd, 2025. That's November 12th. She's over a month from report, from when the court did it, because I threw in 60 days, not 50 days. So she's over a month. I'll hear it when I find out if she's accepted into the program. All right. Otherwise, I'll see you on your motion to modify on January 13th.
Thank you, Your Honor.
Thank you. We are adjourned.
Thank you.
Thank you, Mr. Marco.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.